Aloha, everyone. I'm Eva Andrade. I'm the president and CEO of Hawaii Family Farming. On today's episode of Faith in Politics, we're going to look a little deeper at the lockdowns in the state of Hawaii and the state of unrest. So let's chat about that. Aloha, everybody, and welcome back to the show today on Faith in Politics. And we are bringing back one of our most viewed guests, and that is local attorney Jim Hotchberg. Initially shared with us about some court cases that were happening because of Governor Ige's lockdown orders. And so we are very pleased and honored to invite Jim back to the show today. So Jim, thank you so much for joining us again.
Okay, so today, I don't know when you're going to air this, but this is the 21st of September. Yesterday on the 20th, there was a 7-mile long Trump convoy around the island. 7-mile long. So I think people are quite upset. And I think they're upset about a lot of the politics involving the COVID stuff here. I think if they're thinking people, they're probably upset about the lack of transparency from the health department through the governor and the mayors, not giving us the information that we really need to understand the conditions on the ground here with respect to what kind of risk we're at with COVID. But I do think hopefully, maybe finally in Hawaii, people are actually going to vote their values, I hope.
Well, we're definitely going to talk about that a little later, about how important it is for people to cast that vote on election day. But, just in case there are people watching that may not know about all of the legal problems that the stay-at-home orders have caused in the state, why don't you give us a little bit of a background on what happened in the initial lockdown order that happened way back when? You were an attorney who actually weighed in against these lockdown orders. And if you could give us an update on those cases, that would be really helpful. So fill us in. What happened? Why are we at the point we are today?
Okay, so on March 4th, the governor issued his first proclamation declaring a COVID state of emergency, which allowed him to exercise pretty extraordinary lawmaking and punishment powers without any input from anybody else. And that was supposed to be because in February and early March, if you think back, we didn't know as a nation or as a global community what was really coming out of this virus. If we remember all the way back to February and March, there was a huge consensus that it was so contagious, everybody was going to get it, and it was so deadly, everybody was going to die. On March 4th, when the governor made his proclamation, he said in his proclamation, we don't have any known cases here in Hawaii, but because the World Health Organization says everybody's going to get it and everybody's going to die, I'm going to issue a state of emergency to protect us. And people were okay with that. Because if it was true that everybody was going to catch it and everybody was going to die, you got to do something. That was the understanding on March 4th when he initiated his state of emergency. The law that he used, if anybody wants to look it up, it's Hawaii Revised Statutes Chapter 127A, and there's like 32 sections in that statute. It's not a big long one. One of them, Section 14, says that it's the governor on a statewide level or the mayor on the county level that has the sole authority to determine if there is, in fact, an emergency, and then they can do the emergency order. But the last paragraph specifically says, on the 60th day after the proclamation of the state of emergency automatically ends, it terminates automatically, unless by separate proclamation, the governor had earlier terminated. So there was a 60-day maximum outside length of life for the state of emergency. This law was passed in 2014, so it's relatively new. It replaced the old civil defense law that was more geared towards Cold War issues and things like that. So as we got close to May 3rd, which was the 60th day, and I noticed that the governor was issuing proclamations that went past May 3rd, I started to get a little bit concerned about him violating the law. And so in June, I had clients that wanted to challenge the travel ban. And I had a co-counsel from the mainland, Harmeet Dillon, and her charity, Center for American Liberty, that a law firm charity like Alliance Defending Freedom and the ACLU, that kind of thing, to co-counsel with me. The reason that that's important to a local attorney doing a pro bono case, which means I know I'm not going to charge and the only way I get paid is if I win and the state has to pay me back, which does happen. In order to make it possible to do it for free, these charity nonprofit law firms that share our values provide the resources to do it efficiently and economically. So when I finally got Harmeet to be co-counsel with me and we had our clients, we filed our first federal court lawsuit on the travel ban. Our clients were people that lived here and that did not live here. We had 4 clients. 3 of them did not live here, but owned real estate in Hawaii, had intended and had plans and airplane tickets and stuff to come back to manage and take care of and repair and improve their properties. And the one that lived here needed to leave and come back after visiting her mother in an old folks home and couldn't afford the trip and the quarantine. And so that was the universe of our claims. People that live here can't leave and come back in quarantine because they got to work. And people that couldn't come because of the quarantine when they got here, the quarantine was so strict. If my clients that were going to come back home to deal with their property did not have everything in the property that they needed to do the work, they wouldn't be allowed for 14 days to go to Home Depot to get a tool, a piece of material. They actually, in some condos, weren't even allowed to go in the hallway to put the trash down the trash chute. Okay, that's how weird this was. So we sued, and we filed a motion for a temporary restraining order, which is a motion asking the judge at the very beginning of the case, before any evidence is taken, before the state of Hawaii actually filed a response to the complaint, to order, we were asking the judge to order that the state could not enforce the travel ban because we were likely to win. And in the meantime, the violation of our clients' rights, because we were likely to win, should lead the court to stop the governor's travel ban. And the reason that was important is, if you noticed and you remember, at the time, you could drive from California to New York or Florida or Maine through states, and you had the right to travel between states. It's kind of still like that, although some states are doing unconstitutional things and being sued and challenged and stuff. But Hawaii, you obviously can't drive here. You can't take a train. You can't even take a boat because they're not letting them moor. So you have to fly. And because you are a captive audience coming off of an airplane in the gangway and into the terminal, you were captured and required to quarantine, which is unconstitutionally violating the right to travel that you have, just like all the people that can drive on the mainland between states. There was no question that that should win. So we filed the suit and we asked for the relief. The legal test in the case is, does the state have a compelling state interest to violate that right to travel? And if the answer is yes, the second follow-up question is the government using the least restrictive means to accomplish that compelling state interest? So we knew that they were going to argue the compelling state interest was COVID and the medical harm to the community. So we hired a California university professor who was a medical economist who looked at the COVID statistics that the health department was providing in June, in June, and had a professional scholarly opinion in the form of testimony in writing that Hawaii did not have a medical emergency based on COVID, and therefore there was no compelling state interest. So we submitted that to the court with a second argument that even if the court thought there was a compelling state interest. You can't quarantine every single person getting off a plane, just like we got in big trouble for quarantining all the people of Japanese ancestry without knowing whether any in particular were spies or not. And the Supreme Court made that ruling. You just can't mass quarantine people because of a non-specific quality. And they weren't testing anybody. They were just saying, you're getting off an airplane, you're quarantined. And they would do very invasive things. When you got off the plane, they would ask you for your cell phone number and where you were going to be staying, and then they would call that cell phone number while you were standing in front of them to make sure it rang and it was really your number, because they were going to chase you down during the 14 days. So anyway, so we had a hearing on the motion for a temporary restraining order, and the judge, a local judge, actually appointed by President Trump, but first nominated by Obama. She was not given the judgeship by Obama's nomination through the Senate, but apparently, according to Chad Blair's, forget his internet news thing, but they had a story on her that said that Jill Otaki was allowed under Trump to become a district court judge in Hawaii in exchange for a conservative from Hawaii on the Ninth Circuit Court of Appeals. So it was kind of a political trade-off. So we got her. At first, we were kind of excited because we thought, wow, a Trump appointee, how lucky can you get? Well, we were wrong. Anyway, she denied the motion because she said she was not going to replace the elected officials' opinions on the medical condition in Hawaii with her own federal judiciary opinion. And to support that, she used a paragraph out of Justice Roberts' opinion in another COVID case at the Supreme Court, but it was his own opinion. None of the other 8 justices signed on, and she relied on that. So we are actually dismissing that case. Our clients got so fed up, they've actually sold their properties in Hawaii, or they've moved away from Hawaii. They're done with this place. One of them is still in the case, but not on his own. So there's a stipulation this morning before the court to dismiss the case without prejudice, which means it can be brought again with different clients or the same clients. But right now, based on her order, it wouldn't be a very good appeal because there's no record. No, discovery was done. It's the very beginning of the case. It's better to appeal a case when you have a more full record so that the appellate court has more to look at.
Now, since we're not...
That's the first case.
Okay, now just so we're, because we're not sure when people are going to be viewing this, today is September 21st. And so,
Correct.
When you're watching this, we want to make sure you're able to line that up. For those of you, again, that may not know who he is, Jim is a local attorney here in the state of Hawaii, but he is also part of Alliance Defending Freedom, which is an organization, a national organization. We'll put their website on the bottom of the screen in case you want to know more about them. The Alliance Defending Freedom attorneys do a lot of pro bono work. So if you feel like the Lord is leading you to maybe donate to an organization that fights for religious freedom, then please consider maybe giving a gift to Alliance Defending Freedom. And so, Jim, we do thank you for your ongoing work for religious freedom here in the state, because you've done that for a number of years. So thank you very much for your service to the state.
Well, you're welcome. And because ADF focuses on religious liberty and the right of churches and families and that kind of stuff, they are not really involved in COVID cases unless it involves the right to worship in a church, which none of my cases here do. And there are other cases here. Would you like me to just quickly mention? So one of the first cases that was filed was actually filed against the governor's COVID stuff on behalf of a labor union on Kauai. I have no idea how that came out. Another case was filed at the same time I filed my federal court case by For Our Rights, and they voluntarily dismissed their case. They've now filed another case on Kauai, and I actually have another pending case in Kona, which I'm happy to share the details about, because I really only know the details about my own cases. So in July, I was called by a couple of a family, a mom, a dad, and the mother-in-law of the wife, So a mother, her son, and his wife. And they had gotten cited in their townhome complex for being at the pool, even though it wasn't public property. They were part owners of the pool. You know, when you are in a condominium or a townhome, you own a percentage of the common element. And so they got cited for violating curfew, or not curfew, quarantine. And they hired me to file a complaint in Kona, which is where they live. When you file a state claim, you file it in the district where the people live. And so instead of a U.S. constitutional right to travel claim, the state claim focuses on state law. And the gravamen of that claim was the 60 days ended May 3rd. So the citation in July was unlawful because it was issued after the powers of the governor and the mayors had expired, and they never created a new state of emergency. All of their proclamations, all 14 of the proclamations from March 4th through the last one in the end of August, all specifically by their language, started off citing the March 4th proclamation of a state of emergency, and then each one in serial goes through all the prior proclamations, tacks on the new one, and then the next one does the same thing and tacks on the new one. So they all were relating back to March 4th, which by the language of the statute ended May 3rd. So we sued to ask the court to declare everything after May 3rd on this COVID nonsense to be invalid, unlawful. And the mayor of the Big Island and the governor's attorneys filed motions to dismiss the case, and I filed a cross motion for summary judgment, which are two different ways to get at the same thing depending on if you're the defendant or the plaintiff at the very beginning of the case. And the question on the motion to dismiss is there any set of facts, any law that the plaintiffs could win under? And if there's no way they could ever win their case, then the court's supposed to dismiss the case. It never really ever happens, because even if the plaintiff doesn't plead something that could support their claim, if they raise it in the response to the motion, or if the court thinks of it on their own, the case survives. And the reason for that, the policy in Hawaii is we really do want cases resolved on their merits. We really don't want to throw them out unless there's really no way this is a real case. The standard for the motion for summary judgment is kind of the mirror image. If there's not a single issue of fact that creates a genuine material issue, then the court, as a matter of law, should be able to decide the issue. You don't need a trial. And so I filed a motion for summary judgment. I said, Judge, this is what the law says. On the 60th day after the proclamation of the state of emergency, it automatically terminates unless the governor, by separate proclamation, terminated it sooner. May 3rd has come and gone. My clients got cited after May 3rd. There is no state of emergency under the citations that my client got. Throw it out. And throw it out for everybody in the state, because according to a recent news article at the time, the HPD had issued 10,000 COVID violation citations. So this was a very widespread problem. So we had a hearing on all three of the motions at the same time. The judge actually listened to the attorney general representing the judge, arguing that every time a new proclamation was issued, it gets 60 new days. And there's nothing in the law that says the governor can't do that. There's nothing in the law that says he can do it, but there's nothing that says he can't. And therefore, because everybody's going to get COVID and everybody's going to die, mind you, this was on the 1st of July. They were still arguing that. The governor, because of that deadly, contagious thing, needed all the power that the statute should broadly give him. I pointed out to the court, well, if you look at their proclamations, that's not what they ever once did out of 14 tries. Every one of them referred back to the March 4th proclamation, creating the state of emergency. Every one of them linked every single previous one into the new one. So they have never claimed to create a new 60-day state of emergency, ever. And therefore, they can't use that argument. The statute's unambiguous, and you've got to look at what the statute says. So the judge agreed with me. She said, Mr. Hotchberg, it's an unambiguous statute. So under the law, when a statute is not ambiguous, that ends the inquiry. If it's unambiguous, you're supposed to apply it. But she didn't. What she did is she said, I agree it's unambiguous, but I think the governor's reading of that unambiguous language, and she ignored how they actually had acted under that unambiguous language with never creating a new state of emergency. She said the governor's reading is the better reading because everybody's going to get it and everybody's going to die. So she actually dismissed the Kona case on that ground, saying there is not a single scenario where my clients could win their case, which is wrong. So right now, on September 21st, the attorneys, the three parties' attorneys, me, the governors, and the mayors, were working on the language of the order that the judge is going to enter sometime probably at the end of the month. And then we have 30 days to appeal. And the appeal will ask the Intermediate Court of Appeals, was the judge right or wrong in how she handled the question? And unfortunately, in Hawaii, the governor nominates all the state judges, and the Senate in the state of Hawaii consents to their appointments. And there's only one jersey on that process in the state of Hawaii, and it's Democrat politics. So we get judges that are going to protect the governor, even in these circumstances.
You have made.
So we need to use our votes to have people in office that are going to represent our views. And if we don't vote based on our values, they're not going to represent our views.
You brought a really good point up, and I think that so all of these court cases, right, could have been alleviated had the legislature just went in and fixed that 60-day rule, right? I mean, they had the opportunity to do that in the 2020 legislative session. They kind of sort of had a bill that might have done some of that, but the bill ended up dying. Well,
let me address that, because the governor's office actually argued in the Kona case that it was absurd to think that the legislature could be ushered back into session when there's an emergency going on to nitpick the fine details that the governor has to have the flexibility to deal with. And our response to that was, well, Judge, it's really interesting because they actually did. I had another case in the federal court, the travel ban case, and when my motion for temporary restraining order was pending before the hearing in the end of June, because the hearing was on July 2nd, at the end of June, the Senate did rush back into office. They took a House bill, they gutted it, and they put in travel restriction language, passed it within a week, and we had our hearing on September 2nd, or on July 2nd. The judge issued her order that day. We had the 4th of July weekend, came back after the 4th of July weekend with the knowledge that the judge had denied our motion, so they didn't need to do anything. And who guessed? The House refused to take up the bill because the emergency on their half was gone. But we argued to the judge, no, actually, they actually did try to do it when it was required of them. So they actually could. And in fact, like you just said, since this case was filed, if they wanted to change the 60-day rule, they could have done that, and they didn't do that either.
Yes. So I guess the bottom line is, if this is an issue that continues to come up, the legislature could end this discussion once and for all by getting in there and clarifying this ambiguous language, right? I mean, if they just did that, we could move forward.
And I have a speculation about that.
Yep.
So Governor Ige can't run for governor anymore. He's already been a senator in the state of Hawaii. Most of the time, people don't run for lower offices after having higher offices. So in 2 years, his term limits for him expire except for higher office in the typical thing. So my speculation is that the Democrats all got together and said, you know what, we're going to let Ige eat the bullet on this COVID stuff because you can't make the right choice. no matter what choice you make, people are going to be mad about it. We all have to run for office without, the House and the Senate, they don't have term limits. They can run until they drop dead. So I have speculation that they were putting it on the governor because he can carry the burden and it won't affect their future elections. It's all speculation. I have no knowledge of any conversation that ever occurred, but it makes sense to me. I grew up here. Politics is exactly what they are.
Yep. And actually,
so,
we only have a couple minutes left, and I actually want to tie a couple of really good points that you made together. You mentioned earlier that we elect the governor, and then the governor appoints these judges, right? And then the Senate will confirm them. That's how it works in Hawaii. Well, on the national level, you elect a president who then will nominate judges for the Supreme Court, and then the Senate will nominate, or the Senate will vote on those appointments. So in this last couple of minutes, Jim, I want you to really very clearly, as an attorney, articulate to people how important voting is for these top positions, albeit governor, albeit president, because that makes a difference on where we could end up legally at some point on a variety of religious freedom and faith issues.
So I'm going to talk about that based on the September 21st coverage on the news of Senator McConnell and Senator Schumer eulogizing Ruth Bader Ginsburg and then presenting their positions on President Trump replacing her either before the election or before the end of the year when the new Senate comes in, okay? So everybody go watch those clips because they're very, very enlightening. So if you are a traditional values human being, you support religious liberty, you're pro-life, you're all the things that Eva's organization has supported for decades in Honolulu, and you're watching Justice John Roberts flip-flop like Kennedy did and like Sandra Day O'Connor before him as the fifth of 9 judges making 5 to 4 decisions on cases at the Supreme Court. If President Trump can replace Ruth Bader Ginsburg with another Gorsuch, Alito, or Kavanaugh, we don't have to worry about Justice Roberts being on one team or the other, because there will be 5 of our kind of original interpretation judges who view the Constitution always the way Clarence Thomas has since he got appointed. That will protect religious liberty for decades.
So as we end today's show, it is your responsibility, viewer, to check out the candidates running for office, and both of the presidential candidates have put out their list of potential Supreme Court nominations. So take a moment, research them, because who you vote for, as we always say here on the show, is going to keep on voting. And so we want to make sure that you're taking time to research the candidates and you're making that vote according to your conscience. So we thank Jim for joining us today, and for faith, family, and freedom. We'll see you next time. Mahalo, everybody. If you liked today's video, make sure that you like it, that you share it with your friends, that you subscribe, and then hit that notification button so you'll know every time we upload a new video. Mahalo, everybody.